All right, welcome back to another special episode of The Unknown. My name is Michael Volpe. I report at michaelvolpe.substack.com, and I live in Chicago in Cook County, and my partner, Rich Luthman, lives somewhere around Fort Myers in Florida, Lee County, named after Robert Edward Lee. And we are joined by State Representative Gil Gatch from South Carolina, and you're a Republican, right? Almost all of them are Republicans in South Carolina. So I wanted to have you on because you've proposed a number of bills on guardian ad litem reform. I'm going to take it off. I think this is what's called establishing foundation in the law. First of all, what is a guardian ad litem and what are they supposed to do?
Yeah, thanks for having me, guys. Like you said, my name's Gil Gatch. I'm here in the Low Country of South Carolina, Charleston County, Dorchester County. If you guys know where Somerville is, it's a really beautiful historic town, and I invite everybody to come because we've got great food and coffee here. So come on down. But a guardian ad litem is used in lots of different areas of the law as it relates to family court. The guardian ad litem can be a lawyer or a layperson, and they're ordered by the court to investigate the issues related to the children. So the idea is that if you have a lawyer representing mom and a lawyer representing dad, there aren't any lawyers who are unbiased or any representatives, even if they're not lawyers, looking after just the children and their best interests. So the theory is that these people who are guardian ad litems will investigate where the kids live when they're with mom, where they live when they were with dad. Do they have food, adequate clothing, toys? Obviously, is the place safe? No open holes in the walls and, animals running through the house, like deer running through the house because there's no doors that are closed and things like that. So the guardian ad litem is meant to make sure they're looking after the best interests of the minor children.
But isn't that the job of the judge? Isn't effectively when you have a guardian ad litem, or isn't the judge like pointing out the judge's job is to make sure that the fit parent gets more custody? Isn't that everything you're saying? Isn't that the judge's job?
Think of it like this. A judge sits on the bench one day and they may hear 15 different cases. That judge isn't able to be in every place at the same time. So the guardian ad litem is supposed to be the eyes and the ears of the court and look into what's going on and then report back to the court. Now, I think where you might be going and there is a problem here is that oftentimes, and I don't believe this should happen, the guardian ad litem goes beyond just reporting what they've seen and heard. They begin to weigh in on who should have the kid and who's the better parent. And unfortunately, guardian ad litems are people. People make mistakes. They have bias, even if it's unknown. This politically divisive climate we live in right now, you can imagine, let's say I have a client and he's always wearing a MAGA hat. He's a huge Trump supporter. There probably aren't a ton of MAGA hat wearing guardian ad litems around. So unfortunately, a guardian ad litem in that particular instance might judge my client, not because he's a bad father, but because he's weird to them. And that can sometimes color the report that the guardian ad litem gives. And I'll say this really fast. There's a huge glitch in our code, which it's Title 63 right now in South Carolina law, where a guardian ad litem is not allowed to give a recommendation in a final hearing. So let me say that again. Guardian ad litems are prohibited by law to give recommendations as to custody at a final hearing, unless they're asked by the judge at that final hearing. And then there's case law to say that there should be some good reasons to do that. However, there are lots of other hearings that happen before a final hearing. And there is no prohibition on guardian ad litems making recommendations in their preliminary reports. So oftentimes you'll see a preliminary report happen by the guardian ad litem with recommendations. And I've made the objection before, like, hold on a second, you're not allowed to give recommendations. And the response from the court is, oh, that only applies to final hearings, not temporary hearings. And I'm like, well, what the heck's the point? If they're going to weigh in on this and put their thumb on the scale, if we prohibit it at a final hearing, which is obviously very, very important, don't you think we should prohibit it at a temporary hearing? So that's another loophole, I guess you could say, in the law that needs to be fixed.
Your client, I assume, is then prejudiced, probably legally, at the final hearing if it goes the wrong way. And I assume you can't challenge what the conclusions at the preliminary hearing at the final. Am I right?
You can challenge it. You can challenge it, but once you
But
have a temporary hearing,
not with the guardian ad litem. Like, can you quit? Like, if they gave recommendations against your client at a preliminary hearing and they're testifying, can you challenge what they said at the preliminary hearing?
you certainly can. We call that impeaching evidence. If we're trying, the guardian ad litem is meant to investigate in an unbiased way. The unfortunate reality is that it's very difficult to get a judge to sign on to the idea that a guardian ad litem is acting biased. And since there's no prohibition in the law against making recommendations at a temporary hearing, sometimes people will have a temporary order from a temporary hearing that lasts a year or 2 years or longer. And that the basis of many of the temporary hearing orders are founded upon the guardian's recommendation. So it's a little hypocritical in a way, because it's like, well, this order that's meant to basically set the standard for the entire case until the final hearing is based on a guardian ad litem recommendation that's actually prohibited at the final hearing. But it doesn't really matter if it's prohibited at the final hearing, because it was let in early and it's basically clouded the judgment of the entire case. So what we need to do is we just need to get rid of the guardian ad litem recommendations. Like you said, the judge is the one who's elected. However they're elected, judges are the ones who are elected. They're the ones who were screened. They're the ones who have the power of wearing that robe, not guardian ad litems. I believe the guardian ad litem should just be the eyes and the ears of the court and not weigh in with their sort of presuppositions about how a dad or how a mom should act. I mean, that's not really what I care about a guardian ad litem. So long as the kids are safe and the parents are not a threat, the guardian ad litems don't need to weigh in on who's a better dad or who's a better mom or who's a better parent.
All right. So I got an article that was you and another person. I think this is a quote from you where you said too much power, that you believe guardian ad litem have too much power. What do you mean by that?
Sort of a lot. Yeah, I did say that, and it's a lot like what I was just outlining for you. Guardian ad litems, when they make those recommendations, they like, think about this for a second. So you get a new action. Mom and dad file actions, and mom and dad. Let's say in a particular example, in some situations, you can have mom and dad living in the house with the child, and they go to court for the first time to find out who's going to get the house, who's going to get all the time with the kid, who's going to have to pay child support and alimony, who gets to have to pay the mortgage and pay the bills and health insurance and all these things. The judge in that temporary hearing makes the decision that becomes an order that is the law of that case, sometimes for more than a year. Okay? When the judge looks at the situation, if the guardian ad litem weighs in on who should be the parent, the judge almost every time goes along with what the guardian says.
Right.
So let's say mom and dad are both great parents and they should really get 50-50 custody. Maybe mom should get the house because dad has the ability to go live somewhere else. But if the guardian ad litem says, dad's a hard worker and mom's always been the one to take the kids to the doctors and always been the one to take the kids to school, dad responds, well, yeah, I know, because I'm the one who's been making all the money. I have to go to work at 6 a.m.
Mm-hmm.
That's not a reason why I shouldn't get my kid. The
Mm-hmm.
judge will say, I'm going with the guardian. And in that instance, the guardian has all the power. It's almost like the guardian is the judge in a lot of circumstances. And then dad ends up having to move out. He only gets to see his kid maybe 6 days a month. And he's being penalized because he was the guy who always did all the hard work and was the one who was making the living so that the kids could have, a nice life and so that his wife could have a nice life. And then if there's if the wife, sometimes every situation is different, but it is not uncommon where the wife realizes she's looking at her. And again, it doesn't have to be, I'm not saying that every woman in the case is bad, because that's not the case. I see this happen a lot where dad makes all the money. Dad has a lot of retirement. He has a lot of income from his job. Mom's been a stay-at-home mom, doing a great job as a stay-at-home mom. Mom decides, you know what? I'm sick of dad, and I'm still young. I want to move on. So if she talks to a friend or a lawyer, she realizes that she gets 50% of all of his retirement, 50% of the value of the house. If the house is, $1 million, $2 million, that's a lot of money. And she's looking at those dollar signs. And then if she can get majority of the time with the kids, she's probably in one of those instances. I've seen $4,500 a month alone just in child support. So there's no, so long as she can get a good temporary agreement or temporary order coming out of that temporary hearing, she's kind of set, and there's no incentive for change. It's and the guardian ad litems have a lot of power in which way those temporary hearings go.
All right.
Gil, I think that what you're describing, Mike, I think what you're describing is something we talk about all the time, and it's been addressed. I know what we've covered in Arizona and Idaho, temporary orders that become the status quo, and how judges don't like to disrupt the status quo. Do you think that there should be strict time limits on temporary orders in family court, that they have to be scheduled or addressed within 30 or 45, 90 days? Do you think something like that might help?
You mean revisiting the temporary order afterwards?
Yes.
I mean, there's no strict rule. I mean, I'm not opposed to it, but again, I mean, it just kind of creates the same issue as because what you said is correct. If there's a status quo, the judge is very, very hesitant to undo it. So it becomes this catch-22. The guardian ad litem's report is used and basically heavily relied upon to create the status quo. The status quo continues for what, a month, 2 months, 3 months, and then we look at it again. Mom, if she's the beneficiary of a good order, she knows that I have to be on my best behavior. So nobody's doing anything bad. Nothing changes that would be a substantial change in circumstances, as we call it in family court. So the court would just see the same scenario, and why would they change it? I mean, there's not a lot of.
There's two issues here. One is that with a temporary, but also an ex parte order is really the big issue. It becomes more of a legal strategy where one side runs in. A lot of times it's the mom runs in, claims that there's all sorts of issues, potentially even a silver bullet, where there's allegations of criminal activity or there's allegations of endangerment, and they don't have the benefit of any test from the other side, any cross-examination. They get the order, obviously, by the judge seeing it. The judges are politicians too. They have to sign it because, God forbid, they don't sign the order and something happens to the kids. So that order then becomes the status quo. It's an ex parte order, but may not be addressed by the court with a full hearing with cross-examination for 3 months, 6 months, a year. And then at that time, the lawyer who ran in and brought the ex parte order says, well, this is already the status quo. The children are already in a school situated. They have their activities. Mom has been managing them for the past 6, 9 months, 12 months. Therefore, I see no reason to change the status quo. That seems to me like a due process violation for the side that didn't run into the court. What do you think? Yeah. And what would be done?
That doesn't happen in South Carolina. Ex parte orders can be issued, but because they're without the due process element that you mentioned, they have to have a hearing on them in an expedited fashion. Normally, it's within 5 days, depending on scheduling. Usually, it doesn't go for much longer than that. It certainly doesn't go months. I've never seen an ex parte order more than 10 days. I think is the rule. What?
The law, it sounds like the law has addressed that. So other states should be looking at South Carolina to make sure.
Yeah, I mean, I don't believe an ex parte order can be in control for more than 10 days unless by consent. But I could double check that rule. But no, normally it's, a hearing has to happen. Now, you said something about cross-examination. There is no cross-examination in these hearings. These are under the Family Court Rule 21 in South Carolina, and they're not evidentiary in that same way. They are paper hearings in a sense that the lawyers can argue them, but they come from submissions of affidavits and other documents. They're not, there is no cross-examination of anybody. The court just reads the documents and makes a determination.
Do you think they
That's a
should
little
be?
scary.
Do you think they should be evidentiary hearings with cross-examination and put someone under oath and give the
I
other
mean,
side
I don't have any problem with that. I think the reason why the court does it that way is because of time. Because as soon as you start cross-examining somebody, if you've ever been in a courtroom,
I've been in a
and
courtroom, but that seems
doors are
like
opened up, it
that,
takes. I mean, it would. I don't personally mind it because I'm the lawyer who's advocating for my client. I think from a judiciary from their time standpoint, judicial economy is what I was trying to say. I don't know how many hearings we'd be able to get through if you had cross examination on every single one of them. So I
I,
mean, I
I,
wouldn't be
bel
against it, but I'd see where they're coming from on that.
I believe in criminal court, an affidavit has very limited like effect because you can't cross-examine it. So in the interest of judicial expedition, it sounds like it's a due process issue. If people can just put anything they want on paper and there's no way for the other side to challenge it directly.
No, I think
Um,
that what you're saying is, I think really where you're getting to, which is something that just changed, and I was against it at first because it was going to make cases more expensive, but then I'm actually for it, and the change is it's just begun, so we haven't really felt the effects of the change yet because it started on October 1st. But Rule 21 now used to be, well, let me say the way it used to be. It used to be that you just brought your affidavits to the hearing and you'd have to read through them real quick to see what the allegations were so that you could respond to them to the court on the fly. You had to get really good at that. And a lot of the time, you would sort of be ambushed by information that was wild and that you would, be like, wait, did you read this client? Like, what's the answer to this? You'd have to, it was really, really sloppy. So now that's totally changed. The affidavits have to be submitted prior to the hearing so that responses can be made by both parties. That's much more helpful, and nothing that's outside of the affidavits can be considered. So that's a lot better than the way that it used to be. But the thing that you touched on that I think is really, really important, and I see this all the time, is, and I just talked to a judicial candidate who wanted to have a meeting with me, and I was telling her this. I said, if you become a judge one day, I want to see judges be more hard on lawyers who go beyond truth telling. Another way you could say that is lawyers who lie, because when lawyers go well beyond the truth to try to win their argument, it's very rare that you see courts coming down hard and sanctioning the lawyer for overstepping the bounds of which I believe is their call as an officer of the court, which is our rule of candor to the tribunal. I just think that judges don't want to be mean. And this kind of goes to one of the topics that I think you guys wanted to talk about, which is how we elect judges.
mhm.
One of the ways that judges are often found unqualified are through these anonymous uh, grades that they get from the bar, members of the bar, other lawyers. And so I think judges oftentimes will be very hesitant to be hard on a lawyer for lying because they are scared about what effect that'll have if they want to get reelected. So it's really difficult. I think that we moving towards a system that takes um, I don't know if our new system actually addresses that yet. I think that it needs to be, and that may be something that we can bake into it as we go through the committee process, because the bill hasn't been filed yet. But we need to be careful not to disincentivize judges for coming down on truth versus lies. Judges should make sure that they have um, just no patience at all for lawyers who are telling blatant lies. That's not good.
Okay, and you've got
Well,
I think
there's an
7.
issue, Gil, though, Mike, real quick about before we move on to something else about Luana Bell. It's a story I read, preparing for the interview about guardian litems. I realized that guardian litems in South Carolina aren't required to be attorneys. And in that
Correct.
Bell case, she was actually a convicted felon And one of them ended up in jail for failing to pay the GAL fees for somebody who never should have been at GAL in the first place. So you're talking about judges coming down hard on lawyers who've taken the bar and have passed the character and fitness and everything else, and are members in good standing. But what about people that can just walk in off the street and be a guardian ad litem? What impetus does the judge have in that case?
I think if I could reframe that for you, I totally hear what you're saying. But there's a bigger problem, because it isn't just that someone who isn't a lawyer can become a power position or a power player in a family court case. It's that guardian ad litems have no accountability, really, as to their good or bad, their bad acts. So, for example, there's a case that I am very familiar with, where there was an attorney guardian, and before my time in the knowledge, this didn't happen with me. It didn't happen in real time. It happened before I became aware of it. But what took place was an attorney guardian had surreptitiously recorded a client who was having a very bad moment because her child had run away. Now, you guys might not know this, but in South Carolina, lawyers are forbidden to record anybody for any reason ever. We're not allowed to record. The Supreme Court, I think the language actually says in your capacity as a lawyer, but the Supreme Court has basically said you're always a lawyer, so you can't ever record, okay? It's an ethics violation, and you can be suspended or reprimanded. Technically, you could lose your law license over it. Well, this attorney guardian had surreptitiously, secretly recorded this lady, and then used those recordings to take her custody away from her totally. Okay? So then I got involved, and I found out about it. And so I brought it to the court's attention, and the court didn't do anything about it. The court said, you're going to have to notify the Office of Disciplinary Counsel if you think it's a violation of the ethics rules. So I didn't do it, but the client did. And what does and the ODC, I know, but the ODC with the Office of Disciplinary Counsel right now takes the position that they don't have jurisdiction over guardians, whether they're lawyers or not. They certainly don't have jurisdiction over non-attorney guardians, but they also sort of take the position that because it's an attorney guardian and in their capacity as a guardian, we're not going to do anything. So what does that create? It creates an environment where if you're an active lawyer or not, if you're a guardian ad litem, there's no disincentive to do the ethics, to abide by the ethics rules, right? So we need to, I think the way that you fix it is you create legislation. I think I already have this bill filed, where the guardian ad litem lawyers are under the purview of the ODC, so that if they violate one of our lawyer rules, ethics and professionalism, professional responsibility, then you would, have to, account for it. I think that disincentivizes bad actors. And again, this is all about disincentivizing bad acts. The reason why people do bad things is because there's no disincentive to do them. So, they cross the line, and unless they're just a really moral person, if they're winning because they're crossing lines and there's no disincentive to cross lines because nobody's coming after them or at least reprimanding them, then what kind of an environment do we live in? It becomes not a good one.
The counter argument to not to having someone besides a lawyer be a guardian ad litem, based on the definition you gave at the beginning, well, why does it need to be a lawyer? Somebody investigate that you're saying they investigate the parents and make sure that there's enough food and there's no holes in the wall. Why does that need to be a lawyer? Why can't another layman be the guardian ad litem based on what you said a guardian ad litem is supposed to do?
Yeah, so that's a good question too. A case that I had where there was a lay guardian ad litem, her fees for the case were about $25,000. Mm-hmm. The guardian ad litem is the one who, under the code, is ordered by the court to have a cap of what they can charge. They can ask for it to be increased, but they have a cap. If you go to court at a final hearing, if the guardian ad litem is not a lawyer, and some lawyers do this, they will hire counsel to represent them because they're not lawyers, okay? they don't have the ability to represent themselves in court. They don't know how to object to things because they don't know the rules of evidence. So they don't know how to admit and authenticate evidence, all of those things. So I saw a case one time where, although the guardian ad litem, who was a lay guardian, had $25,000 by the court order, that's all she could charge. She hired an attorney who charged $350,000 in fees. That lawyer's fee was not capped because that's another loophole in the law. And so the client who lost the judge ended up ordering that the client who lost pay more than half of the guardian ad litem's lawyer bill. So
what I'm hearing you say is actually they do need to be a lawyer because they're going to be in court, so they need to know how the law works. I get one last
I think
question.
there are certain circumstances that would warrant a lay guardian if there's consent. I'm not opposed. I mean, there are some really great lay guardians out there, and I have met several of them. I'm not saying that every lay guardian is a bad actor. The biggest problems are just, what's the oversight on guardians, particularly if they're not lawyers? What's the oversight? What's the remedy if they do something that is wrong, illegal, bad, so on and so forth? What is the remedy if there used to be the new code is under Title 63. It used to be, I think it's Title 26, I believe. It might be 20 something. I think it's 26. It used to be under 26. And when it was under the 26 title, there was a provision that allowed you to sue a guardian ad litem for gross negligence. But when it got taken out of Title 26 and under Title 63, that was left out. So there needs just to be some type of oversight. There needs to be some type of disincentive. And there needs to be guidance that, guardian ad litems are not allowed to weigh in and put their thumb on the scale for one person over another person. Obviously, if a person is harming a danger, doing drugs, selling drugs, anything criminal, beating somebody up, like psychological abuse, that, those are obvious things that need to be reported. But if there's just a parent and one's, likable to the guardian and one's not likable to the guardian doesn't need to weigh in on who she thinks or who he thinks should get the kid just because she likes this person better than this person. That's not okay.
Do you think that the answer then becomes guardian ad litem immunity and limiting guardian ad litem immunity specifically? Is that something legislatively doable for you?
Yeah, I mean, I think that we can, by statute, put the guardian ad litems under the purview of the ODC if they're attorneys. And if they're not attorneys, I do believe we need to probably redraft and put back into the code that if a guardian commits gross negligence, which is the way that it used to be worded, that they can be subject to civil liability. And that creates what? Disincentive. Why? Because there's a risk that if I do something wrong, that I'm going to get in trouble for it. So I'm not going to do anything wrong, not just because I'm a good person, but because I don't want to get in trouble.
In Missouri, and this is through case law, the guardian ad litem have immunity that's akin to a judge. They call it quasi-judicial immunity, and that was not by statute. That's by enough lawsuits that the courts basically created for them. Hopefully we can get through. They got 7 bills, and you might have proposed some other ones, but to reform guardian ad litem. But this one says ban ex parte communications. You got to explain this to me. I thought, I'm not a lawyer, but I thought ex parte communications were bad, and they're generally banned. How are guardian ad litem allowed to have ex parte communication? And for the non-lawyer, that means they're talking without the other side present. So
the ex parte communications bill, and it may need to be tweaked to make sure that the language is a little more clear, but you'll see, I came in as a 39-year-old, 40-year-old lawyer practicing for the first time. I've only been a lawyer since 2020, in South Carolina. I graduated law school from Georgetown Law School in D.C. in 2019. I worked for a judge for some time, and then in 2020, I ran for office. My community wanted me to run for office. I ran for office, and then I couldn't work for the judge anymore. So I've been practicing in South Carolina since around February of 2020. As I began to move into this world as not a young person, but as a new lawyer, I began to see very quickly that certain lawyers and guardian ad litems were buddies. And then certain guardian ad litems and therapy, child's therapists, reunification therapists, clarification therapists, custodial evaluators, co-parenting therapists, that lawyers and guardians and these experts were all like thick as thieves. And it became clear to me that, like, in my case, the opposing lawyer they were having all of these like off the record conversations, like, rubbing elbows and stuff. And I'm like, well, hold on a second. Like, if you're talking about the case, I mean, I'd like to be involved in that because I want to know what you're saying. So I always ask in discovery for all the communications between the guardian ad litem, the opposing party's law firm, the opposing party's lawyer. That's not privileged information. I want to know what's being said without my knowledge, because if there's some funny business going down here, I'm going to bring it up, because I don't want the guardian ad litem being poisoned against my client simply because the opposing attorney and the guardian have been, like, drinking buddies, for years. That's not okay.
Is that allowed now?
Yeah.
There's no ban on the guardian ad litem getting together with the judge and or the lawyer without you, the other lawyer, being there and discussing things, and presumably.
I didn't mention the judge. Ex parte communications with the judge is illegal. You can't have. I can hang out. I can hang out with the judge.
Right.
I can hang out with a judge and say hi. Like, if I see a judge at the coffee shop and say hi, obviously I can't talk about the merits of the case without the other party or the other party's attorney present. That would be ex parte communications. But what I'm talking about is the guardian ad litem or the therapist who the judge essentially sort of 90% of the time just goes along with them. If the attorney and all these people are like buddy, and they're all hanging out all the time, they're talking about my case, and I can't hear what's happening, how will I know if there's illegal bias taking place on behalf of the guardian? The guardian needs to allow me to be involved in all the conversations that she's having with the opposing attorney. Now, the guardian can interview each party, obviously separately. That's fine. The guardian will do that. That's the guardian's job. But if the guardian is going to be having a conversation about the case with the other attorney, I would like to hear what's going on, because I want to make sure that I'm,
and so that's
supervising that we're not being funny.
That's not banned. Am I right?
But
that's not banned. No, you can do whatever the heck you want.
Mike, to make it clear for the audience real quick, it's the judge, and you said it, Gil, has the guardian ad litem as the eyes and ears of the court. Let's say the judge has a guardian that they have appointed to 4 or 5 cases. There's no problem with the judge calling the guardian ad litem in alone and saying, hey, what's going on with my cases on my docket? That's, I think, perfectly fine. The question I think Gil's worried about is, let's say a meeting like that happens. The guardian goes in with the judge, and then it's buddy with the attorney for one side, and Gil's on the other side, and that other attorney has the full report from the meeting with the judge, and Gil and his client don't have that. That becomes something I think that is an egregious ex parte type situation.
I got an article I did a few years ago out of Missouri. That's what was happening. In these text messages, the guardian ad litem and the lawyer are scheming to, in one case, stop the mother from putting her daughter into therapy. I mean, this is like very serious stuff.
Well, I have a situation that happened not that long ago where there's an attorney who used to be a therapist. Now she's a family court attorney. And the therapist that she always uses is this one particular lady most of the time. And the children in my case were involved in therapy with that lady. There were allegations made against my client. So what did I do is I subpoenaed the email communications of the therapist to find out what was being said between the therapist and the opposing attorney. And they were making fun of my client. They were making fun of me. And I'm like, so hold on a second. This therapist who's going to testify about the child and who she thinks the child should be with is making fun of my client and me and doing it to the opposing attorney? I don't think so. That ain't okay. So that's why I think that there should be more stringent rules surrounding that type of communication. Obviously, if I'm a lawyer, I have lawyer friends. sort of. I mean, my wife and my kids are my best friends. I kind of hang out with them all the time, but I do have lawyer friends. I understand, you might say, oh yeah, man, that case was crazy, right? Like, or, oh, that's a tough one, man. Or, so, but like, you shouldn't be talking to guardian ad litems about your case and the attempt to sway the guardian ad litem or manipulate the guardian ad litem's position without the opportunity of the other lawyer to be present to guard against those types of things. I just don't think that you should be able to do that. Now, how do you guard against that? I guess it's difficult, but it's the same way you guard against ex parte communications with judges. It's real. I mean, I guess technically I could go to a judge right now and talk to the judge about the case, but that is against the law. You're not allowed to do that. And so I don't do that. So I think that if it's in the statute, it's going to be a disincentive, and maybe people try to play funny with it, but the first time somebody gets smacked for it, people won't do that anymore.
All right, Rich, you got a few questions?
Yeah, there's two really hot issues in family court, and you have a couple of bills that address both of them. You have a bill H3608, which would allow jury trials in certain family court proceedings.
Right.
And you also have a 50-50 presumption of custody under H3481. Can you talk a little bit about those proposals?
Absolutely. The jury trial issue, Georgia does jury trials, and they don't have a terrible time with it. I've had a lot of people, this is their most passionate negative response that they have is to the jury trials. The issue with jury trials for me isn't so much as it relates to a jury saying who gets custody and that type of thing. What I've experienced is it relates to finances and attorney's fees is the big problem, and then contempt as it relates to going to jail. So, for example, I mentioned to you a moment ago that this guardian ad litem who had a lawyer, the guardian ad litem's lawyer had racked up the $350,000 bill, and the court, not a jury, the court determined that the client who lost not only had to pay over half of that guardian ad litem lawyer bill, but also a huge portion. I mean, it ended up being over $200,000, and this guy didn't make 50-something thousand dollars a year. So to me, I think there was no due process for this person who was prejudiced financially in an egregious way. And, when I think about the Constitution and due process, I think about being able to go before a jury of your peers to determine what's fair and reasonable. This is sort of absent in that financial aspect with regards to family court. So I think of jury trials in regards to attorney's fees particularly. And the other one is as it relates to rules to show cause or contempt actions, going to jail. People go to jail in family court all the time. And the theory is that it's not against due process because it's civil contempt, meaning that a judge will say, if you pay this fine or you remedy this particular issue, then you sort of got the keys to the jailhouse and you can let yourself out. It's not mandatory criminal time. I still think going to jail is going to jail. I still think that, as it relates to being guilty of something that allows you to be ordered to go to jail, that due process wise really affects sort of my heart. And I have seen, and I have an appeal right now. I believe it's pending right now. I have an appeal where the court did order mandatory jail time for my client for allegedly violating a provision of their marital decree, which was an order. And you can't do that without either a jury trial or beyond a reasonable doubt or both. You have to remember, beyond a reasonable doubt is that threshold of evidence that in criminal court, it's very, very high. It's not 100%, but you have to get well close to it as humanly possible. The person who's bringing the case against you has to convince the fact finder that you have violated these things beyond a reasonable doubt. But in family court, it's just clear and convincing evidence, which is just above the preponderance test. So if like preponderance is 50% plus one, clear and convincing is just above that a little bit, and then beyond a reasonable doubt is well above at the very, very top. If you go to jail in family court, it's at that clear and convincing threshold. I just think that having a judge who's sending you to jail requires just a little bit more safeguards, because your freedom is being infringed upon. And I think that the Constitution is clear, but we're working on that too.
What I'm hearing you say, so for contempt, where you could go to jail, you want juries?
I think that, yeah, I think so. I think if you have the opportunity to go to jail, then I think having juries of your peers determine whether or not you're going to jail is important. That's just me.
Right.
Now, I think a judge can send you to jail. Let's say you step up in court and you start throwing down F-bombs and pointing the finger at the judge. Obviously that's contempt. He can throw you in jail for that. But if we're talking about, I dropped the kid off 3 minutes late on a Saturday, and the opposing party says that I should go to jail for willfully violating the order. You're only required to have 10 days notice. Did you know that?
Right.
So think about this for a second. Let me phrase it another way. If you were charged with A and B third in South Carolina, the most time you can spend in jail is 30 days. Okay? That's assault and battery, 3rd degree. You'd call me. I'd contact the solicitor. We call them solicitors in South Carolina. I think they call them district attorneys everywhere else. Mm-hmm. They're the prosecutor. So I'd contact the prosecutor. I said, hey, here's my Rule 5 request to get all the evidence that you have against my client. And then we get to look at it. We get to marshal a defense, and then we get to go to court and marshal a defense for a 30-day maximum exposure sentence. In family court, the maximum exposure is a year. Yeah. And when they file the rule to show cause, they only have to, when they serve you, they only have to give you 10 days notice that the hearing is happening. 10 days. You hire me, we got 8 days left, and I contact the other attorney and I say, hey, I would like to see what evidence you have against my client so that I can marshal a defense. They can go, no. And you know what? They don't have to give it to me because there's no discovery allowed in rules to show cause in family court. So I don't get discovery. I don't have the opportunity to marshal a defense with anything substantive. In criminal court, I got that with a 30-day maximum sentence, but you've got a year maximum sentence, and all I get is 10 days notice and a hope and a prayer. I don't know. It just doesn't seem like that's very equitable to me.
Rich, any other questions?
Just my thoughts.
Yeah, can you address the 50-50?
Sure, we've got a bill coming out. I had filed one that's 50-50. Rom Reddy and Doge SC picked it up and was very, very excited about that. I think we're going to file a new bill that incorporates all the language of my bill and adds a couple of other things. That's going to be announced today, I believe. And so essentially, the way that family court law in South Carolina works today is under 3 main cases, Clark, Mixon, and Scott. The court cannot give parents equal parenting time unless they find extenuating circumstances. And 90% of the time, extenuating circumstances is a situation where the status quo has been 50-50 parenting time for already, right? Since before you get to the hearing. So that's one of the things that I do is I say, hey, client, try to get 50-50 custody with your spouse of the kid, 50-50 time, so that when we get to court, I can make the allegation to the court, hey, you, judge, there's extenuating circumstances here because they've been operating 50-50. That's the only way that 2 parents can get 50-50 split time. The case law actually says, guys, it is not in the best interest of the minor child to have equal time. It says that it's not in the best. I just don't think that's correct. So instead of beginning with a situation where one of the parents only gets 6 days a month and the other parent gets the rest of the time, unless you can prove extenuating circumstances, let's just reverse it. Let's say it's, the default that the parents who are able, willing, and fit can get 50-50 time. It's just the default. Now, there may be a lot of reasons why that's not good. Parent could be a truck driver, is never home. Parent is a drug dealer and is home, but doing drugs from the house. Somebody beat somebody up. The parent
Workaholic.
just drive drunk with a get.
What is
Yeah, there could
workaholic?
be a thousand.
Right.
Yeah,
I
there
mean,
could be a thousand reasons.
I
Yeah,
don't think Elon Musk should ever get 50-50 because he's never around. Um,
that's what I'm saying.
I
So there
don't
should be reasons
necessarily.
why.
I don't necessarily have a problem with that because I think that's structured with a lot of holes. But the argument against 50-50 as the presumption is no two families are alike. So why are you like fixating on one solution as the answer? What do you think of
Well,
that?
I mean, I think the argument cuts. I think the argument cuts just as harshly the other way. I mean, no two families are alike. So why are you making the presumption that one parent automatically only gets 6 days a month? I mean, if
I,
you're going to
I,
lean one way or the if you're going to lean one way or the other, you have to. I think the best way of looking at it is what's the lesser evil, right? In one scenario, let's say the 50-50 custody scenario. The possible evil in the new scenario, the 50-50 presumption, is that one of the parents gets more time than they should, right? They shouldn't get 50-50, but the court messed up and they got 50-50. That's the evil in that scenario. The evil on the other side, the way that it is now is that the court should have given 50-50 and the parents both deserve 50-50, but one of them got the shaft and only gets 6 days a month. I think that if you're looking at those two evils, it's way worse that a parent who should get 50-50 only gets 6 days a month versus a parent that shouldn't have gotten 50-50 gets more days. I think that I'm going to lean towards, you know what, if parents who shouldn't get more time got more time, I'm going to have to be okay with that versus all these guys and all these girls that should get 50-50 and the court just does this, sorry, can't do it. And then they go, well, great, I have this, have my son and I'm missing their second and third birthdays and, I'm just getting 6 days a month and I'm missing their entire childhood and like everybody's fine, but my spouse wants more child support and she knows that if she gets more time, I have to pay her more money. I think I would rather lean towards the other direction if I'm going to pick one.
All right, Rich, you've got a few more questions.
I can go off topic. I have just a couple off topic about South Carolina and politics and your task as a legislator. Especially with this family court stuff. This family court stuff kind of transcends party lines. Yet you do have your base. How do you weigh that? How do you balance that when you want to build the bipartisan support for some of these family court bills? Have you found bipartisan support? Do you have people on the other side of the aisle that you can talk to on this stuff, or has national politics polarized everything so much? The MAGA camp, the non-MAGA camp, the left, the right. When you're making these sausages, is it easy to make them, or is it difficult?
It's never easy to make sausage, unfortunately. I feel like I'm in a Groundhog Day movie, but I'm in middle school and I can never graduate. I'm just in middle school every day sometimes. The issues with the family court are bipartisan, and they're tripartisan in a sense where you've got people who are on both sides of the aisle on the moderate world, and you've got people on both sides of the aisle who are in the sort of the radical sides of the party, if you will, the fringe folks. There's a lot of different people within the party there, and these do transcend all of those lines. And I've got support from people all over, Democrat, Republican, woke, right, all the things. So that's really positive. There is a little bit of pushback from the bar, or at least there has been in the past. It hasn't happened this year yet, but in previous years, the bar has been very hesitant to support it, and I think that's probably saying it a little too nice. But the reasons to me, while I understand where they're coming from, I just find them unconvincing from the standpoint of the best interest of the minor children and for parents' rights. I do totally get that change is never fun. I do totally get that there's always a bit of a transition period when we're doing change, that there'll be a little bit of awkward, stumbling around as we move forward with the new system. But despite that, I think that payoff is well worth the price of that struggle, because it means that parents and kids will be with each other, in theory, a lot more. And I just can't imagine being in a situation where my son and my daughter, for nothing I've done wrong, but because the law and the system is created and made a certain way that I'm not allowed, if my wife objects or my ex-wife objects, that I can't see my kids more than 6 days a month. That just seems horrible to me. So I think that it may be a little uncomfortable moving forward. I've heard that it removes the discretion of judges. I would say two things to that. One, we remove the discretion of judges all the time. That's what legislatures do. We make laws. So, for example, there was a bond bill in criminal court that removed the discretion of the judge from giving time served to a person who was incarcerated, and got reincarcerated while out on bond. That removed the judge's discretion. That's just one example. We do it, I would say, in the current system. We've removed the discretion of the judge to give 50-50 time unless it finds extenuating circumstances. We don't give them discretion to do otherwise, and they never do. So this isn't really removing discretion. I just think that it turns the focus in the opposite light, saying, okay, we're going to, look at it this way first. Give me some good reasons why we shouldn't do split, and the judge has the discretion to make that decision. So I don't necessarily agree, with all due respect, to my friends at the bar on that issue. And I think that there's a good way forward for the benefit of kids and their parents to figure out a way to get it done. So I hope that we can get it done.
Well, I think you have a heck of a bargaining chip with the guardian ad litem stuff, in the sense that if you raise the standard of guardian ad litem to a minimum standard that said that there's an educational requirement or a training requirement, same way lawyers have every year, a couple of years, they got to do CLEs. You do that for guardian ad litems, but you say that lawyers, are automatically qualified by holding a law license, and you get also a buy-in from the to say that it's gross negligence, in the sense that your lawyer insurance right now would cover your guardian ad litem stuff. I don't think that the bar could have too much of a problem with those types of things.
You know what? That's the first time I have ever thought about that argument. That's brilliant. The argument would be, well, hold on a second, ODC. You're saying, like, so you're saying, excuse me, hold on, Supreme Court. You're saying that the guardian ad litems are not subject to the Office of Disciplinary Counsel, but if they do something, would their malpractice coverage cover?
Yeah, how you would do it is this. You have a minimum standard for a guardian ad litem, separate and distinct from the practice of law, but lawyers get to opt in automatically. Like in some states, if you hold a law license, you automatically hold a real estate broker license, or you already are automatically a notary. You're automatically a lot of things. That is another automatic thing a law license confers upon you in South Carolina. Correlative to that, there's now an educational requirement. So let's say you're a 20-year cop. You know how to investigate. You're a good person, diligent. You understand the rules of evidence and the candor before the court. You take the course every couple of years. You continue with your CLEs. You're certified by the state. The lawyer doesn't need to get certified by the state, and you get the GAL at a gross negligence standard where you can bring a civil lawsuit. So a plaintiff side lawyer can bring against somebody. You'll have a mandatory insurance requirement for all these people. So the insurance companies will be happy. They're going to pick up new clients. And you have a rider written in there that it's gross negligence. So attorneys' malpractice doesn't go up because it doesn't cover gross negligence for an insurance for malpractice insurance. So I think it's a win all the way around. The lawyers will be making more money because they'll be able to sue. The insurance company will be making more money because they're getting all sorts of premiums from non-lawyer guardian ad litem. And you'll have an educational requirement that'll be supervised by, I don't know how you do it in South Carolina, the Department of Education or some department, but it's outside of the purview of the courts. Or it could be under the courts. The court could make an office, the Supreme Court could make an office of guardian ad litem education and produce guardian ad litem education courses and discipline through that structure as well. So it's a way to do an end run around and get everybody happy. But
these are good ideas.
It also make a better service for the consumer of the legal services of the family courts. It makes it so that you don't have a guardian, that a litem that every couple of years has a continuing education requirement, and that has a regulator that looks at what they do.
These are good ideas. You should run for office in South Carolina.
Oh no, they wouldn't have me.
I don't like it because I think there's too much money in the system, and what he just described is pouring millions into the system. The idea I always had is not just the elimination of guardian ad litem, but all court appointees. I don't understand why is a family court judge, and they can do this in probate too. Why are they allowed to appoint a guardian, appoint anyone? I use this example. If you're involved in a complex, I don't know, a breach of contract case, the judge can't go, this is really complicated, so I'm going to appoint a forensic accountant to help me. You can't do that in a civil case. It's very limited in criminal. Judges, I think, can appoint in certain cases, like a psychiatrist to make sure the person's not crazy. But why are family court judges allowed to say, this is complex?
It's because the answer's, I think, sort of simple. They're not allowed to appoint the forensic accountant, like you said, because they're talking about investigating the facts of a bank account or whatever it is. But in the guardian ad litem issue in probate court and family court, you have a person who is unrepresented. You actually have a person. So like sometimes in probate court, you can have a person who's in jail and they're unrepresented because they're in jail, but they're still technically a person with vested interest in the estate. Well, the court would need to appoint a guardian ad litem to make sure that the person who is unrepresented understands their rights in that particular instance. Or if you're in probate court and you have an incompetent person who's alleged incompetent, and there are two people fighting about who is going to be the conservator or guardian over this particular person, well, the court needs to make sure that the person who's incompetent has a representative to make sure that like no funny business is happening between advocate one and advocate two. The court's going to want to be able to rely on somebody for their eyes and ears about like, okay, what's your take on this? So the judge just can make a better decision. I don't have a problem with guardian ad litems in family court with kids. I just have a problem with the guardian ad litems putting a thumb on the scale. The guardian ad litems should not use their minds from the standpoint of giving recommendations. They should just use their senses and say, look, mom and dad are good, house is good, food is good, or maybe dad doesn't have any food in the house, so the guardian would say dad had zero food.
Isn't that like the Child Protective Services and or police rule? If it's so bad there's no food in the house, that's what Child Protective Services is for.
They get involved sometimes, but I don't think you want Child Protective Services involved anytime.
I don't, but the scenarios you're giving, basically you're saying unless what they're supposed to do is figure out if one parent is so bad it's dangerous, and that is what Child Protective Services is for. So I think it was last year, they called it the Ad Hoc Joint Legislative Committee on Judicial Nominations. Now, I don't think you were on the committee, but were you following what was going on?
Not really. No, I don't really recall what happened in that committee. I sit on so many committees right now. I'm kind of more living my world there with public utilities and tort reform. Those are the big things that I deal with in my capacity as a leader or whatever. I'm obviously very passionate about the family court issue and judicial reform issue, but I don't recall that committee. I just don't recall that.
Do you think family court reform is such a pressing issue that a similar committee should be formed for reforming family court?
We have a family court law subcommittee of judiciary. It's not like an ad hoc committee to investigate. I would just like to get the change.
The difference is it's a special committee because the whatever issue they're looking at is so pressing that you form this special committee to investigate it. So do you think it's worthy of a special committee that the problem is so significant?
I'm not against that, but it just adds another layer and delay. I mean, I think that we can argue about this in the committee system that we have now. I mean, my bill never got a committee hearing. So, I mean, we haven't had the opportunity to talk about that particular bill. And some of the other bills that I had, you know, some of the committee members weren't present when my bills were put. And there's several of my bills in family court that have been heard at the first subcommittee level that have not been voted on yet. I just think that going ahead and moving forward, I mean, because if you do an ad hoc committee, you're talking about like 6 months. I mean, I might not be elected again by the time, you know, by the time we get done with the committee. You know what I mean? Like, I'd like to be able to argue this
They've got
as soon as possible.
They've got them in 2 states. I think the reason they want to have them is because the issue is complex. So before you present any proposals for reform, you take a lot of testimony to see what the problem is. From those committee hearings, that's where they kept hearing about 1 year, 2 years, 3 years temporary orders. That's where they came up with the idea that a temporary order should actually be temporary, among other ideas. So that's the thought process is, before we come up with reforms, let's take a lot of testimony so we figure out what the problem is and what some of the forms are.
I mean, that's what the subcommittee and committee process is for. I mean, you know, we don't need to have every bill. I mean, you'd be surprised, but you know, the Public Utilities Committee is I chair the, you know, Energy Committee, which is called Public Utilities, and we had the South Carolina Energy Security Act that came through that. It's a very sensitive topic because we had the giant VC summer debacle that took place in, you know, 2017 about lots of people went to federal prison through fraud. It's nuclear energy combined with natural gas, demand side management, all kinds of SMRs, which are small modular nuclear reactors, and the pilot programs. Talk about complicated. I mean, I could bore you to tears for talking to you about it, but just because it was complicated and it was very nuanced didn't mean that we needed to have like an ad hoc committee on the issue. We just had several subcommittee meetings where everybody who was a stakeholder got to come to the table on the record, you know, on television and recorded and everything. And we just got to have those meetings then. And then at the end of it all, we got to vote on it. We got it passed. And thank God that we did, because we really have a problem with energy in South Carolina. We're going to lose 50%.
I think the problem, the difference is that the Supreme Court of the United States has said in Troxel v. Glanville that you have a fundamental natural law right to be a parent and to have the parent-child relationship. And I think that when you open up these family court ad hoc hearings, you have an inpouring of people. And it's not something that's complex like nuclear reactors. It's something that's very, very simple. It's something we learn about every day. Every major religion, you open the Bible, you see it. It's the parent-child relationship, and I think that's the value in these ad hoc hearings, in these ad hoc committees on family court, because the more that our government gets away from 2 very simple things in family court, a custody determination and a property determination that are very simple, that everybody can understand, that the more that our government gets away from that, the more our government loses its real, I guess, its strongest basis, you know, the strongest confidence that the people can have that the government's doing the right thing.
I don't disagree with having them. I just think that if we do have them, you're going to find that there's many more obstacles that will be created that get in the way of it actually getting done. So we can do it if that's what people want to do. I just think that those who are going to advocate for it are those who really hope that we can derail it. That's what's going to happen. So if you're for the reform, then you're going to say, let's just do it in the subcommittee process. If you're not for the reform, you're going to say, oh, let's have an ad hoc committee so that we can delay the process. We're going to make sure that we get our people. We're going to assign the committee chairman to the ad hoc, that I know that I can make sure, because, the ad hoc committee chairman is the one who determines who speaks and who doesn't speak. It's not just a free for all. If you're at a subcommittee hearing, anybody can speak, but if it's an ad hoc committee, you don't have to allow anybody to speak. You get to pick who speaks. So I just think that it would be a strategic, bad move strategically if you're for it. That's just me.
That's interesting. In Arizona and Idaho, where they formed, they called it a task force in Idaho, but it's the same thing. they were formed as a result of family court victims flooding their state representatives, like state legislators like you, and it was like an outgrowth of the victims. So and that's what the legislators thought was the best
Yeah,
way.
we just had a poll on this that was done. Let's see if I can find it.
And what were they polling?
On the family court stuff, it was let's see if I can find it. No, that I have it. Dun, 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 dun. It was really, really good. I think it was Doja C did it.
Mhm.
And it was very fascinating. It was like a crazy number, like 97% of the people thought that it was an important issue, and I think 98% believed that it was an issue that they would vote for somebody or not. Yeah, it's right here. Hold on a second.
Among your legislators, would you say the polling would be the same or no?
No,
So the
no.
legislators aren't representing the view of the public on that issue, I think.
It might just be because they don't know it. This is the
But
first poll
isn't
that I've.
that what an ad hoc committee is designed partially to do, to get the whole legislature to hear about what's happening?
Yeah, I mean, all committees are for the public to come to.
Right. No, I know,
Yeah.
but you're
You're not going to convince me that it's a good idea to have an ad hoc committee on this position.
All right.
I mean, you can
Rich,
say it over and over again, but I'm telling you,
I got it.
being a man who is on ad hoc committees, I promise you that if you want this to happen, you're going to say, let's do it publicly in the subcommittee process where everyone will be given and afforded the opportunity to speak, not in an ad hoc committee where the chairman, who's ruled by whoever the leader is picking and choosing, cherry picking certain people to speak. I mean, that's a very real possibility. I just think that it would be a really bad idea. But there is a shared parenting polling that came out from October in November 2025. And it says there's 97% believe that it's in the child's best interest to have as much time as possible. 94% believe that it would change their vote on a candidate, depending on how they voted. 93% believe that the state should promote shared parenting, and that's huge. 93% of polling showed that South Carolina wants to move in this direction. So, I mean, it's pretty huge.
Okay, we can talk forever. Let's go for another 10 minutes. Rich, you got any other questions?
I'm good. I'm good.
Okay. Yeah. Anything else you wanted to add?
No, I mean, I just would hope that whoever listens to your show would remember it's really easy to be passionate in these types of issues. I have learned that conveying my belief in the most professional way possible tends to have a better response. It's sometimes not what you say, but how you say it. So trying to couch down the passion part and it's really hard if you're one of these parents who's been aggrieved by one of these scenarios. But I wouldn't necessarily go into telling your personal story. I would just say, look, I am an advocate for this. I've seen how bad this can be. This is a hit close to home for me. And if you and just try to say it in a way that's keeping in the back of your mind that the other person, you're trying to win them over. You're not trying to beat them up, because we got to win hearts and minds on these issues. And sometimes winning hearts and minds can be that whole goal can be screwed up if you're, really super upset when you're talking. It really just will alienate somebody without ever really investigating into the truth of the matter. So just try to be careful that the way you convey your opinion, try to do it with the idea, like, I want to win the hearts and minds of the person that I'm communicating with. And, pray that the Lord gives us favor,
I agree with that. And a lot of parents are so traumatized by what happened.
Sure.
They come off repellent. They don't mean it, but people just
Because
don't
they're hurt.
understand. Yeah, they're
hurt
at a very core level, and it comes out. It is unattractive unless you understand why it's happening. All right, State Representative, thank you for being here.
Thank you, guys. Appreciate it.